Judges Jakupak and Breges, as I said, will give a presentation on digitalization, and they will in fact present us a summary of the EU directive on the introduction of digital tools and processes in company law. So, Ms. Jakupak, Ms. Breges, please, the floor is yours.
Thank you, Christian, for introduction, and hello to everyone from Commercial Court in Zagreb, Court Register Department. Let me start with some introduction that we judges as a practitioners in justice sector confront difficult challenges in sorting through how the flood of different e-justice technologies affect the accessibility, legitimacy, legality, and economic of a judicial system. These judicial values are crucial determinants of the quality of justice and the adoption of e-justice technologies, and should depend on how they affect those values. This presentation is about digital age of company establishment and digital age in Court Register Department of this court, so the future of it. In highlights factors that must be considered in deciding whether an information and communication technology project is likely to improve the judiciary performance and in turn support political and economic development. There are around 24 million companies in the EU, out of which approximately 80% of them are limited liability companies. Around 99% of limited liability companies are small and medium enterprises. Every year, around 2.5 million new companies are created. It is difficult to estimate how many of those companies would register online if this was possible across the EU. High growth of enterprises play an important role, of course, in contributing to the economic growth and creation of jobs. In order to facilitate the registration of companies and their branches, and to reduce, of course, cost, time, and administrative burdens associated with the registration process, the directive put in place procedures to enable registration to be completed online. In Commission's research from 2018, they found out that only 17 member states provide for a fully online procedure for registering companies. For example, advanced online tools and solutions had Denmark, Estonia, and Latvia. So need for action was because of the Commission noticed that national rules on the use of digital tools either differ from country to country or do not exist at all. And we come to EU company law package, making the best of digital solutions and providing efficient rules for cross-border operations. We come to the Directive 1151, which covers provisions on the use of digital tools and processes in company law, and Directive 2121, which lays down new rules on cross-border conversions and divisions and amends the rules on cross-border mergers. About first mentioned directive, the digitalization of company processing, setting up a company or registering a new branch of a business should be straightforward. That is why the EU passed legislation to make sure that it's possible to register certain types of company and branches online. It's a limited liability companies. The new rules should apply from August 2021. This will cut costs, especially for small and medium-sized enterprises. The law also states that fees collected by government should be set in a transparent way and cover the cost of the service provided only. And it will also make it possible to submit company-related documents online. For reason of public interest, and only for reason of public interest, to prevent identity misuse, alternation, fraud, or something like that, applicants may be required to appear physically, But however, this should not be systematically, but case by case basis. The new legislation obliged member states to make procedures speedy, just 5 days to set up a company online, or 10 days to register a branch online. So also interconnected registers will enable information to be circulated among member states. And one advantage of this is that information on disqualified company directors will be shared among member states. They may then decide in accordance with their national laws to take this information into account and even refuse certain appointments. I have many questions about that, starting with the definition of disqualification and that, and I see some problems already, but I hope we'll manage it well. The result should be a more modern business, helping companies to thrive and prosper across the EU internal market. Any requirements as to authenticity and accuracy and due legal form of any submitted document or information should be subject to national law and in compliance with Regulation 910 from 2014. Once only principle should apply, that companies only have to submit a specific document one time to one authority only. When it comes to Croatia, in Croatia, we have 3 ways to establish a company. We have in person, when you come to court and with the application and all the documents. We have Hitro HR service from FINA, and we have e-establishment called START. This last one, e-establishment, the Minister of Justice has developed in 2019 the electronic service called e-establishment, which is integrated into information system for starting a business called START, through which it's possible to remotely establish the most common forms of company. This created the conditions for electronic access to the court register and the commercial court via internet, with the use of national identification and authentication system. Advantages of establishing company at a distance online are that all necessary actions are performed without physically going to the commercial court, no more booking company name, the participation of notary public is not necessary, no signature deposit, all submissions are submitted electronically, signing documents with ID card, payment of share capital and all fees by bank cards via internet. The application for registration is automatically submitted through the system to the competent court. The commercial court issues decision on establishment on the form of electronic document. That means that we have from 2019 digital signature. In addition to the court decision, the party also receives the certificate from the tax administration on the OIB and the notice on the classification of the business entity in the register of the Central Bureau of Statistics. Services available 24/7, and their lower establishment cost, court fees are reduced by 50%. On this screen, you can see how many legal entities there are on 1st November of this year in Republic of Croatia. There are around, if you calculate these, there are around 160,000 entities in the Republic of Croatia. The last part, so around 50% of all the legal entities are established in and have establishment in commercial court in Zagreb. There are some data about company establishment in the Republic of Croatia. I put a period in last year, 2019. You see how many establishment were through the Hitro HR service, through e-establishment, and in person. So in 2019, the most of them are in person. In period, the first 11 months of this year, you can see that Hitro HR has the most of establishment, and e-establishment were around 694 establishment of company, because in December of last year it was just introduced, so it's less than a year in production. So when it comes to commercial court in Zagreb, these are the numbers. So Hitro hires the most established company, and there are other ways, as I mentioned earlier. So we made some experiment at the commercial court in Zagreb. At commercial court in Zagreb, there are around 5,000 meters of files that has to be digitalized, scanned or whatever. And we had an experiment, and for 1 meter of these files, it took FINA over a month to scan it. So you can calculate how many will take to digitalize then for 5,000 meters of other documentation.
I have 1 more minute.
Yes, I will skip to. I have just a few to say about cross-border mergers. You know, the cross-border companies mobility is an issue which has been gaining public attention in Europe since the end of the 1980s. Although it is clear from the wording of Articles 94 and 54 of the treaty that companies should benefit from a freedom of establishment, in practice, the scope of this freedom is quite unclear. So the directive sets out a fairly extensive and largely identical process for the 3 legal operations that I mentioned, conversion, mergers, and divisions. In this respect, consideration is also given to the cost incurred by companies. For example, information can be submitted online. The one-time, last-time principle applies, which means that information only has to be submitted once, and information can be placed on the website as an alternative. Various exemptions and simplified procedures also apply under certain circumstances, and that's more or less due to the time I have to say. To conclude with one sentence, positive outcomes require proper design and management of technologies driven to judicial reforms. Thank you very much to everyone. Thank you, Christian. Thank you, Gianfranco, and thank you, Professor Horak, for having us here today. And goodbye to everyone. Thank you.
Thank you, Tina, for your lovely presentation. We're looking forward to your paper. And I assume that a lot of challenges are posed to the companies when it comes to digitalization and also court registers. We will talk about it today more extensively in the next lectures.